Hey everyone, and welcome to another deep dive. This time, we're tackling a topic that's always lurking in the background of our lives, something we encounter every single day, even if we don't realize it. Negligence.
And we're diving deep into the legal nitty-gritty of it all, exploring two huge GE concepts that underpin negligence law: duty and breach.
You've shared some fascinating legal excerpts on this, expert speaker, so let's untangle this web of legal jargon, shall we? In the simplest terms, what does duty actually mean in the eyes of the law?
Well, think of duty as an obligation. It's a responsibility we have to act with a certain level of care toward others, to avoid causing foreseeable harm.
Okay, so it's not about owing someone money, right? It's more about like an obligation to not be reckless and put others in harm's way.
Exactly. It's about anticipating potential problems and taking reasonable steps to prevent them. A classic example is the case of Heaven v. Pender. You've probably heard of it. A painter fell from some poorly maintained scaffolding.
Oh, right. I think I vaguely remember that one from law school.
Well, the court in that case decided that the ship owner who was responsible for the scaffolding had a duty to make sure it was safe, because reasonably, they should have known that a shoddy structure could lead to someone getting hurt.
Makes sense. So it's all about foreseeability. I wouldn't expect someone to predict a meteor shower, but leaving a banana peel on the floor where someone might slip.
Hmm.
That's a different story. But does this mean we owe a duty to every single person we encounter every single day?
That's where it gets a little tricky. There are different types of duty, and the level of care we owe can change depending on the situation and our relationship to the other person. It's not a one-size-fits-all kind of thing.
Okay, so let's break down these duty levels. What's the most, I guess, common or basic one?
That would be what we call the general duty of care. Basically, it means we have a responsibility to act reasonably to prevent harm to others, especially if a normal, prudent person could have foreseen that harm.
Makes sense. But what about situations where there isn't a clear-cut relationship? Like, say, between that ship owner and the painter in that last case, they didn't know each other personally.
You're right, and that's where things get a bit more nuanced. Sometimes a duty arises because of a specific relationship or circumstance, even if there wasn't one before. We call this qualified duty.
Ooh, qualified duty. I like it. Give us an example of that, something relatable.
All right, imagine a therapist treating a patient who's made threats against someone else.
Okay, that's pretty intense.
Here's a heavy example, but a good one. In the case of Tarasoff v. Regents of the University of California, the court actually determined that therapists have a duty to warn potential victims in situations like this. It's about recognizing the unique position of trust and responsibility that therapists hold.
Wow. So even if there's no prior relationship, a duty can just appear if someone is in immediate danger.
Precisely. Another example is when someone voluntarily steps in to help. Let's say you see someone struggling to swim and you jump in to save them.
A heroic bystander.
Well, you weren't legally obligated to jump in, right? But the moment you take action, you've created a duty of care. If you certainly abandon the rescue and make the situation worse, you could be held liable.
That's a good reminder to be careful about biting off more than we can chew, legally speaking. Okay, so we've got this general duty, this qualified duty. What about when someone is on someone else's property?
Now you're talking about premises liability, and that's a whole other can of worms. The level of care owed in those situations depends on the person's reason for being on the property in the first place.
Okay, so like there's a difference between a friend I've invited over for dinner versus, say, a door-to-door salesperson I don't know from Adam.
You got it. The law distinguishes between invitees, licensees, and trespassers, each with a different level of care owed. A good illustration of this is the case of Loeffler v. Sharp. A bar patron wandered into a restricted area that was clearly off-limits and ended up getting injured.
Yikes, not a good idea.
No, not at all. And the court agreed. They decided that because he was trespassing, the bar owner didn't owe him the same duty of care as they would to a customer in the main bar area.
That seems fair. So why should we, the average listener, care about understanding all this duty stuff, even if we aren't lawyers or judges?
That's a great question. I think it's easy to get bogged down in the legal jargon, but at its core, duty is really about being mindful of how our actions, or even our inactions, might affect the people around us. Understanding duty helps us navigate our daily lives with a greater sense of responsibility.
It's like a framework for being a good human.
And that sense of responsibility is key as we move from duty to our next big legal concept, breach.
Right, because it's not enough to just know we have a duty, and it's about whether we actually live up to it, right?
Exactly. We've established that we owe a certain level of care to others, but breach asks, Did someone actually fail to uphold that duty? Did they drop the ball, so to speak, when it came to acting reasonably?
Okay, so if duty sets the stage, breach is about whether someone flubbed their lines.
You got it. It's about whether someone's actions or inactions, in some cases, fell short of what's considered reasonable under the circumstances.
Now, I'm guessing there's a legal standard for this reasonableness, right? It can't just be about what I personally think is reasonable behavior.
You're right. Personal opinions wouldn't hold up very well in court. That's where the reasonable person standard comes in.
Ah, yes, the ever-elusive reasonable person. Who is this person, and how do they always seem to know the right thing to do?
Well, it's not about a specific person, of course. It's more of a legal yardstick.
Yeah.
The reasonable person standard asks, would a reasonable person facing the same situation have acted the same way as the defendant?
So no superhuman expectations then, just acting with a reasonable level of care given the circumstances. Are there any, like, landmark cases that really illustrate this reasonable person idea?
Oh, absolutely. One classic case that always comes to mind is Vaughn v. Menlove. It involved a haystack. Yes, a haystack that spontaneously caught fire.
Wait, a haystack just bursting into flames out of nowhere? How does that even happen?
It was a case of spontaneous combustion, apparently. But that's not the point. The haystack owner claimed he wasn't liable for the damage because he didn't intentionally start the fire.
So he was just minding his own business, and his haystack decided to play with fire. Seems a little unfair to hold him responsible.
Well, the court saw it differently. They said, no, a reasonable person would know that a poorly maintained haystack is a fire hazard. So, regardless of his intent, he breached his duty of care by not taking precautions.
So even though he didn't mean to cause harm, his carelessness got him into hot water, literally. That's a good reminder that good intentions don't always excuse negligence.
Precisely. Now, there are some exceptions to this whole reasonable person standard. For example, we can't expect children to have the same level of judgment and foresight as adults.
Right. Kids are still learning about cause and effect. You can't expect a 5-year-old to fully grasp the consequences of, say, leaving a toy on the stairs.
Exactly. There's a case, Apprehends v. McFall, where a young boy, only 5 years old, was riding his bike and accidentally injured someone.
Ouch, poor kid. I bet he felt terrible.
I'm sure he did. And the court recognized that a child that young can't be held to the same standard of care as an adult. Their brains just aren't developed enough to fully understand the potential consequences of their actions.
Interesting. So age is a factor. What about professionals, though? Like doctors, lawyers, engineers? They have specialized knowledge and training. The reasonable person bar is probably higher for them, right?
Absolutely. We trust professionals to use their expertise so they're held to a higher standard of care. There was a fascinating case involving tugboats T.J. Hooper that weren't equipped with radios.
Wait, no radios? Were they sailing in the 1800s?
It wasn't quite that long ago, but you're right. It seems like common sense now. Anyway, these tugboats were lost at sea during a storm, and they didn't have radios to receive weather warnings.
That's just asking for trouble. You'd think radios would be standard equipment for any boat venturing out on open water.
And that's exactly what the court said. Even though it wasn't standard practice at the time to have radios on tugboats, the court said that the tugboat owners should have adopted this readily available technology to enhance safety.
So they were behind the times, technologically speaking.
Exactly. They breached their duty by failing to keep up with safer practices, even if it wasn't the industry norm yet.
So even if everyone in a particular industry is doing something a certain way, it doesn't automatically make it okay if it's not reasonably safe. That's a relief.
Precisely. Now, on the flip side, in highly specialized fields like medicine, courts are often hesitant to set the bar higher than the established professional custom. Think about a complex medical procedure. It's not really up to judges and juries to decide what's reasonable in those situations.
Right, you wouldn't want me performing brain surgery.
Yeah, Chuckles. Probably not. That's where expert testimony comes in. In those cases, the court relies heavily on the opinions of other professionals in the field to determine what's considered an acceptable standard of care.
Makes sense. It's reassuring to know there's a system for figuring out what's reasonable in such complex and specialized situations.
Okay, we've covered a lot of ground here, but there's one more term I've always been curious about. The hand formula. It sounds a bit intimidating, to be honest. Can you break that one down for us?
Of course. It's not as complicated as it sounds, I promise. The hand formula essentially boils down to a balancing act. It weighs the burden of taking precautions against the probability and severity of potential harm.
So it's like a cost-benefit analysis. Like,
Yeah.
was it reasonable to expect someone to go to a certain length to prevent something bad from happening, considering the likelihood of it actually occurring?
Exactly. Imagine you're at a busy cafe and you leave your laptop unattended for just a minute to grab a napkin. A reasonable person wouldn't do that, right?
Well, I might be tempted if I had my eye on a really delicious-looking pastry. But I see your point. Tuggles, we've all been there. But the AND formula helps explain why leaving your laptop unattended is a risky move.
Yeah.
The effort of taking your laptop with you is tiny compared to the potential cost of having it stolen right here.
Okay, I'm starting to feel like a legal eagle here. So we've got our reasonable person standard, some exceptions to the rule, and even a fancy formula to weigh the risks. But what about situations where someone breaks a specific law? Does that automatically equal negligence?
That's where negligence per se comes into play. If someone breaks a law that was specifically designed to prevent the type of harm that occurred, that's very strong evidence of negligence.
So it's like the law has already drawn a line in the sand saying this is what's reasonable in this situation, and if you cross it, you're on your own.
Exactly. Take, for example, the case of Dalal v. City of New York. A driver hit a pedestrian while not wearing their prescribed eyeglasses.
Oh no, that's terrible.
It is a tragic situation. And there's a law about drivers wearing their glasses, right? The court said, yep, that's negligence per se because breaking that law directly led to the accident.
Makes sense. The law was there to prevent that specific type of harm, and the driver ignored it. But what if you break a law, but it's totally unrelated to the harm that occurs? Like, say I'm jaywalking and I get struck by lightning, not exactly the law's fault, right?
You're right. There has to be a clear connection between the law broken and the harm caused. The case of Victor v. Hedges highlights this perfectly. A man was showing off his new CD player to a friend while standing on the sidewalk, which was blocking the sidewalk, and there was a city ordinance against that.
Okay, so a minor parking violation, essentially.
Essentially. But here's where it gets interesting. A car swerved to avoid the car parked on the sidewalk, jumped the curb, and ended up injuring the man who was blocking the sidewalk.
Ouch. Talk about adding insult to injury. But I bet the court said that the CD player guy wasn't at fault, right? Since the ordinance wasn't meant to prevent freak accidents like that.
You'd think so, wouldn't you? But it wasn't so simple. The court actually ruled that while parking on the sidewalk was wrong, the ordinance wasn't intended to prevent that type of accident. They said the purpose of the ordinance was to keep the sidewalk clear for pedestrians, not to prevent cars from careening off the road.
Wow, that's a tough break for the CD player guy. So even breaking the law doesn't automatically equal negligence if the law wasn't designed to prevent that specific situation. It's all about context.
Precisely. And that's why understanding these nuances is so important. It's not just about black and white. It's about the shades of gray in between.
I like that. The shades of gray in the law. We should trademark that.
Chuckles. Feel free to use it. Now, let's connect all of this back to our listeners. Why does understanding breach matter in our everyday lives? Because it's not just about legal cases and courtrooms, right? This stuff is happening all around us, all the time.
Exactly. It's about the choices we make every single day when we're driving, interacting with coworkers, even just how we maintain our own property. It all ties back to acting with a reasonable level of care, or, as we've learned today, not breaching our duty to others.
Absolutely. Understanding breach helps us make safer, more responsible choices and be more aware of the potential impact of our actions.
So we've journeyed from duty, that sense of responsibility we owe to others, all the way to breach, those moments where we might fall short of that responsibility. It's been quite a ride. Expert speaker, as we wrap up our deep dive into the world of negligence, what's the biggest takeaway you want our listeners to carry with them?
You know, it's funny. We often think of negligence as this legal term that only exists in courtrooms and textbooks.
Right, it sounds very official and serious.
But in reality, it's so much more than that. Negligence is woven into the fabric of our daily interactions. It's about the choices we make, big and small, and how those choices impact those around us.
It's like we're all connected by this invisible thread of duty and the potential for breach.
Exactly. And understanding these concepts, duty and breach, gives us a framework for making more mindful, more responsible choices. It's about recognizing that even our smallest actions can have a ripple effect.
It's about pausing before we act and asking ourselves, what would the reasonable person do in this situation?
Precisely. And that's something I encourage everyone listening to consider as you go about your day. Look for those moments where duty and breach come into play. You might be surprised at how often you encounter these concepts in your everyday life.
It's like we've unlocked a secret code for understanding human behavior and for creating a safer, more responsible world. And on that note, expert speaker, thank you so much for being our guide through this fascinating legal landscape.
The pleasure was all mine. It's always rewarding to demystify these concepts and see the aha moments click for our listeners.
And to you, our amazing listeners, thank you for joining us on this journey into the world of negligence, duty, and breach. We hope you've gained some valuable insights that you can carry with you. Until next time, stay curious, stay engaged, and keep those deep dive requests coming.